Up next, we have our legal panel with moderator Greg Field of Field Fertility. As a third-party reproductive lawyer, Greg represents surrogates, egg donors, intended parents, and embryo donors. Having had his daughter via surrogacy, Greg and his wife, Emily, are proud to be part of this community and help others through the journey from a perspective of having been through it themselves.
Thank you. Hi, everybody. This is the most fun part of having a baby, the part that you all thought you would need when having a baby. This is Legal 101. Contracts, legal issues, and the parental rights process. I'm going to just take a moment, let them sit down, and we'll go through a couple introductions of who's on our panel. Sitting closest to me here, admitted to the bar actually in 1987 in New York, in 1994 in California. This is Judge Amy Pelhams. She represented children and parents in all phases of dependency, legal practice. She's been the legal director of the Alliance of Children's Rights, a nonprofit organization providing free legal services to children living in poverty. From 2005 to 2008, Judge Pelhams was the commissioner for family court and was appointed judge for the Superior Court of Los Angeles County in 2008. Judge Pelhams has been a featured speaker at conferences and law schools and teaches Children and the Law at Southwestern, where she was awarded Adjunct Excellence in Teaching Award in 2005. She has also been a senior fellow at the UCLA School of Public Affairs since 2004. Judge Pelhams is on the Judicial Council of California Family and Juvenile Law Advisory Committee. She received her BA from Mount Holyoke College and her JD from City University of New York Law School. What does all that mean? In Los Angeles, she is the gateway to the parental orders. Thank you for being here. Next to her is Will Halm. He has more than 30 years of legal experience and specializes in assisted reproductive and family formation law with his firm International Reproductive Law Group. He has helped hundreds of intended parents and surrogates and egg donors with contracts and parental rights judgments and has handled numerous cutting-edge cases. Will and his life partner were the first same-gender couple in a gestational surrogacy case to ever receive a judgment ordering both their names placed on the birth certificate as parents. Will himself has since helped many intended parents obtain pre-birth parental rights judgments, both paternity and maternity judgments, which allows both members of the couple to have their names placed directly on the child's birth certificate. Will, his partner, and his 3 children through surrogacy have been featured in a variety of print and broadcast media, including 2020, ABC Evening News, CNN, NPR, the New York Times, the LA Times, and the Advocate. Thank you for being here. Next to Will is Molly O'Brien from the law offices of Molly O'Brien. She has worked in the field of assisted reproduction since 2005. In that time, she has worked for an egg donation agency and a surrogacy agency, where she became familiar with all aspects of in vitro fertilization and egg donation, including the financial aspects of surrogacy. Since becoming an attorney in 2011, she has gained extensive experience in drafting and negotiating surrogacy contracts, egg donation and sperm donation contracts, and embryo donation contracts on behalf of her clients throughout the world. Ms. O'Brien has also appeared before many judges to help domestic and international couples finalize their parental rights and has extensive experience in obtaining all the documents necessary for her couples to return to their home country. Thank you, Molly, for being here. And next to Molly is Lori Myers from Myers & O'Hara. She's a California attorney with 18 years of experience in third-party reproductive law. Lori first researched the area of surrogacy and reproductive law for a close friend in 1995 and never left the field since. She believes in maintaining close contact throughout the process and works hard to build client relationships so that all legal aspects are completed with confidence. Lori has a strong reputation for creating open, trusting relationships with her clients. And I'm Greg Field with Field Fertility, which is the reproductive fertility branch of my firm. I love representing my clients because not long ago, I was in your shoes. I'm a father from Surrogacy with my wife Emily, who you'll hear from later on the intended parents panel. I love the opportunity to guide my clients through the legal process, and please let me guide you through this session. Our session today is 45 minutes long. The first 30 minutes will be presentations from the panelists, and the last 15 minutes will be some question and answers from the audience and questions that I'll direct from our panelists. Will is going to give a short history of art law, as well as talk about his personal experience through surrogacy.
Thanks, Greg. So I'm going to take you through a very brief history over 25 years. I'll try to do that in a couple of minutes. My husband, we were just actually married after 35 years due to tax advice. But anyway, so we're now legally married, but 25 years ago we were looking to create a family, and we looked at adoption and foster care and decided on surrogacy. It was sort of in its infancy, and there was not a lot of information around, but we decided to go ahead and ask a friend to be a surrogate and ask a friend to be an egg donor. In those days, there were not a lot of agencies or professionals who would help a gay couple. So, sort of fast forward, we created 3 kids through surrogacy. Our oldest is 20. We have an 18-year-old and a 14-year-old. So, the legal landscape has changed dramatically. Back 20 years ago when our daughter was born, we actually had to do an independent adoption of her. So, which means we had to get a parentage order declaring the biological donor of the 2 of us as the legal parent, and then the other one had to adopt our daughter as pretty much a legal stranger, which means homesteading, fingerprinting, and an investigation by legal authorities. So we hired 2 nannies, we move into our house, we have our young daughter in the bassinet, and the nannies are saying, wait a minute, we thought this was your child. They were ready to run out of the house saying, we don't believe you really are the parents. So we had to calm them down. And I just thought that was really unfair for us to have to go through that legally. So around this time, we heard that in San Diego, there was a judge who was issuing pre-birth orders or parentage orders for married straight couples. So we thought, okay, maybe a gay couple could do this. And with the help of Tom Pinkerton, whose wife is sitting right here, we walked into a San Diego court and asked them to declare both of us as parents without an adoption. It was granted. So for our son, who was born a couple years later, we actually were placed directly on the birth certificate. So that was huge, and it really does take a village because a lot of people were involved with that. When we first had our surrogacy case with our daughter, we didn't have a surrogacy agreement. I had to go to the library and stitch one together, but I also needed an egg donation agreement. So I went to Andy's firm, and Lori was there, and she helped us with our egg donation agreement. So to see a lot of familiar faces in the past is remarkable. Just quickly, so the big advances has been, now there's a California statute, Family Code section, which acknowledges surrogacy agreements, brings clarity to it, and acknowledges the legality of them. So this is hugely important for everyone in California, and progressive judges like Judge Pelhman, Judge Henning, a lot of very progressive, forward-thinking judges have really used this statute to the benefit of creating our families through surrogacy and egg donation, and we're grateful. So that's my 25 years in a couple of minutes.
Great. Judge Fellman, any comments? Any feedback on his experience, or that's all more common now?
You can't ask me a difficult
I won't ask you a difficult question. I would just, add that it is such a new field, and we're very fortunate in California because I think we probably have the most sophisticated law probably in the world at this point. But it is very interesting to look around the country and see that surrogacy is not legal in many states and certainly many other countries. So we have a really sophisticated statute. It's extremely detailed, and I think we're really fortunate that we have it.
Great, thank you. Thank you both. Next, we're going to talk about contracts. I remember when I got our first contract, even being an attorney. It's a very thick contract, single space with lots of stuff in it, and we're like, whoa. So Molly, could you help us break that down?
Absolutely.
Thank you.
You might remember from the earlier discussion I did, there's the two legal parts. There's the contract, and then there's the finalization. Lori's going to talk about the finalization. The contract, as Judge Pelhman mentioned, there are very specific things in the California statute that your contract must comply with. So you'll see usually a minimum of two component parts to a contract. The first part is going to be the warm and fuzzy, touchy-feely promises that you and the surrogate are making to one another. The second component part is going to deal with the financial aspects. This is one of the benefits to working with an agency, is that the agency will set those financial parts ahead of time. So when you're presented with the surrogate mom that you might be matched with, the financials are already laid out, and you guys have seen them and agreed to them ahead of time. That way there's no awkward negotiation of the fees at this point, because as an intended parent, you don't want to feel like the surrogate's going to change the financial aspects of the agreement. And the same thing goes for the surrogate. She wants the comfort of knowing that those financial arrangements aren't going to change either. So that's a really nice thing that your agency will do for you. So you've got these two component parts. The things that are going to be in the other part of the contract are going to be things like lifestyle restrictions of the surrogate, such as making sure she has a healthy diet and that she's not lifting things against doctor's orders, certain weight restrictions. Also travel restrictions, because depending on where your surrogate lives, we want to make sure she stays within the state where she's supposed to give birth from a certain time period onward. There's going to be the number of embryos you wish to implant is usually dealt with in the contract. How you feel about the possible termination or reduction of a pregnancy also goes in there. We want to make sure all parties understand the liabilities of any such procedures, and that everybody agrees ahead of time. The absolute last thing you want is to be in the middle of a pregnancy and discover that you and your surrogate mother feel differently about that very crucial issue. The contract should also discuss the surrogate always following the doctor's orders, and if she doesn't understand what the doctor's asked her to do, that she agrees to ask questions until she has clarification on what she should do. That helps give you some peace of mind as well as intended parents. Allowing you to be in the delivery room for the delivery of your child or children is really important, and that's handled in the contract. Of course, there might be medical restrictions, such as a C-section, that might disallow you. So you want to make sure you and the surrogate feel the same way about that from the beginning as well. Sometimes, and more recently, I'm seeing things like Zika being addressed in the contracts because everybody is really freaked out about Zika. So we'll sometimes deal with Zika issues, we'll deal with medical quarantine of embryo issues, and those sorts of things. But you shouldn't really see contracts that actually have medical instructions in them, because that can be largely unenforceable. Well, I mean, arguably a lot of the contracts are unenforceable, but California law is very specific about other certain things that must go in there. So you want to make sure that you work with a reputable attorney to ensure that those things are in there, because you're presumptively the parents if your contract complies with the law from the moment that you sign that contract. So technically even prior to conception. Other states have different restrictions, and surrogacy is practiced in states where it's not, maybe necessarily shouldn't be practiced. So you definitely want to consult with a local attorney in the state where your surrogate resides to ensure that you're moving forward safely, because you don't want to be in the third trimester of pregnancy and discover that there's a legal issue. So make sure that you've dotted your I's and crossed your T's as far as what needs to go into a contract from the beginning so that you set yourself up for success.
Great, thank you. And so what we're hearing is, in those contracts, it's really getting the intent of the parties on paper at the start of it. Judge Pelhman, any comments about contracts that you see?
Well, I'm sure many of you saw on the news a recent case which happened to land in my court, having to do with a situation where the surrogate did not want to reduce one of the babies. And, you know, it just highlights the fact that these are, 64-page contracts, and it's really important that the surrogate understands what's in the contract. The surrogate is always independently represented, although the intended parents pay for that representation. And but I think it will behoove everyone if they feel confident that the surrogate really understands what's in the contract and is not just sort of signing and thinking everything's going to be fine.
Great, thank you. So there's two parts to that legal process. One is the contracts, and then Lori's going to talk about the parental finalization process.
So we just talked about the legal contract, which becomes the basis for filing the judgment to establish your parental rights. And one of the things that's so wonderful about practicing law in this area of the law, in this industry, is it's a very collaborative and congenial kind of relationship among the lawyers. And Judge Pelhman just mentioned the importance of your surrogate understanding the contract. And sometimes there's an effort to save money, or I have a friend who's a lawyer who could kind of save us a little bit of money and draft it up or do a review. But the attorneys that have specialized in this field for many years really know the ins and outs. And when we do reviews with surrogates or intended parents, I rely on the fact that I know that these professionals are going to practically walk through the agreement and make sure that they understand it, not the legal gobbledygook. And we try and make these contracts straightforward, but so they really understand. Everybody's talking about teamwork and organization, and it couldn't be more important than in the finalization phase when we really get to that brass ring where we're presenting our paperwork to the court and getting a legal judgment that names the right people, the parents. In the absence of that judgment, a hospital has no choice but to look to the surrogate as the delivering mother and the legal parent in terms of making decisions or potentially a birth certificate. So it's really important to stay organized and work with a team of professionals that will stay on top of this. And so I'm kind of berating the timing issue because you've been hearing all morning about all the pieces that go into this. And once there's a pregnancy, there's such excitement and almost a relief. But you have to keep us informed of the progress of the pregnancy. Typically, we like to get organized and get started after the surrogate is released from the IVF doctor after the first trimester, because even if we are messengering these papers to party, right, left, they are drafted and everyone must sign them. They go to the attorneys on both sides, they go to the intended parent and the surrogate, and the movement of this paperwork is going to take time. And then it has to be filed in court, and each court will have its own set of requirements and processing time. So again, it's super important to keep the attorneys informed and in the loop. The agency representatives are great at that, but if you're doing it on your own, you need to tell us so that we can initiate this paperwork. It will take a month or two to circulate, file, and obtain this judgment. The pieces of it, there are declarations of the parties themselves, factual statements on following doctor's instructions, abiding by all of the provisions in the agreement, that the even a statement that the surrogate abstained from sexual intercourse to ensure that the baby she conceived belongs to the parents. The doctor that did the transfer will sign a declaration. All these different pieces, including the original agreement, the notarized contract, the requirement of the family code is that that contract is signed before medication begins. The court will require the submission of those contracts to identify the parties correctly and to ensure that the contract was signed in advance of the transfer. That's where the intended parent's name really comes from. So pulling all of these pieces together at the right time and filing them is really critical to that timing. Babies don't wait for paperwork. It happens all the time that babies are born. You know, Christmas is always such a busy time. National holidays, I always brace myself. Memorial Day weekend, you just know that there's going to be a baby born early. And we can only help you if we've gotten this process moving at the right pace. If a baby is born without paperwork, as lawyers, we will file motions, explain to the court what's happened, and ask for the judgment to be issued sooner if at all possible. But really the advantage of California and our pre-birth judgment statute is that we can organize this in advance. And so building that team and making sure that that happens is what makes us feel good once we have the legal judgment, to be able to coordinate it in advance with the hospital, to ensure that you are armbanded directly to your baby, to ensure that you're the one making medical decisions for your child. The birth certificate has your name on it, and the baby is released to you directly. One of the interesting things, I think, in the legal judgment itself, it does say that a surrogate has the right to make her own decisions about medication within labor and delivery. So she is still the patient until that baby is born. She decides how to handle her own labor and delivery, and then as the intended parent, you take immediate custody of the baby upon birth. Last, each county, each state has its own requirements for these legal judgments. You must obtain a legal judgment in the state where the baby is born. So sometimes we help with contracts where there's a connection to California with an out-of-state case, but the finalization must occur where that surrogate resides. So again, staying organized, building a team of lawyers who can assist on the second phase from the beginning is really, really important, so that we can comply with all of those local requirements.
Great, thank you. So it's not just a two-step process with the contracts and the parental rights. Keep us updated throughout the whole process, and then it will end up in Judge Pelham's courtroom.
Hopefully the right time.
Hopefully that courtroom. And can you share with us more about the role, your role, and when you see the cases, and when the attorneys come to you, and what the intended parents don't see?
Well, the procedure in my court is a little different than the procedure by the judge before me. And it's a little different because, for one thing, I like things really organized. And I was lucky enough to have a group of attorneys to assist me, and we sort of created our own Los Angeles local rule, which is our checklist. And as we said, the statute is so complicated, and there's so many different declarations and documents that you really want to make sure that they're all there. And so we now have a situation where the attorneys can, they tab the documents, they have the checklist, they sign off on it, and it's always, I always feel more confident when it's an attorney that I know, and when it's an attorney I don't know, I'm going to definitely take that, second and third look at the paperwork to make sure that everything is in order. There's no home study, there's nothing for, intended parents. You're choosing to have a child, and really it's none of my business. I do require a criminal background check, just to make sure, but that hasn't really been a problem. But other courts have required appointment of children's counsel to make reports almost like a mini home study. I don't do that. I don't feel like that's my job, and I don't feel that that's what the law requires. There are some hearings where the attorneys don't even have to appear. Some hearings more to do with international surrogacies that oftentimes I feel a little more comfortable if I have a question, the attorneys will appear. You know, all kinds of interesting things come up here and there. So you know, again, you want to make sure that your surrogate, and if your surrogate has a partner or a husband, that they're on board as well, because we've had some of those situations crop up. So, you know, I don't remember who said it, but it really is, I think, all about communication.
Great, thank you. So we'd like to open it up to the audience for questions, and I have some questions as well. Carol, would you like to start?
A question for Judge Fellman. When you get this package from the attorney for the favor of order, what would make you decline or reject it?
It's a file, and I would decline or reject it if it didn't comply with Family Code 7962.
So for a layperson, what would that look like? And then what would happen
So
after
it would
that?
be, you know, the declarations are not in there, or the contract's not notarized, the embryo transfer took place prior to the signing of the contract, things like that.
So is there another opportunity to clean that up? Is there another chance, or is it, what happens if an embryo transfer is occurred and baby grows?
Well,
Well, I have had
I'm gonna let you tackle that.
for example, the work in China that I've done, sometimes it's really difficult for those clients to get to a notary. And so we're getting everything together, and I have had that situation where I've told a client they've got to notarize it, and I'm waiting for it to come in, and then it just doesn't happen. And so I'm on top of them saying, you've got to do it, and now you're late, and you need to do it again. But I would put something in the declaration stating that, and I would ask the client to then notarize the declaration, so that not only did I explain why the notarization is late, I would explain that it had to do with finding a notary in Beijing, and then how difficult that was, and that he did it as fast as he could, and then I would ask that that be notarized to show the court that yes, we've identified the right person, and this is why I'm not in compliance, and then it's in her discretion to decide whether that's adequate or not.
There is a, I'm sorry, there is part of the statute which says basically if there's substantial compliance, you can approve it. So, you know, if I have a situation like was just mentioned, that's not integral, that was just procedural, so.
I was also going to comment on that same part, that if the case is deficient in some way, it doesn't mean you're not the parents. What it means is that the court can call a hearing to find out what they want to know.
Questions? Let me ask you a few questions from now an attorney, but from an intended parent's perspective recently. So how do I know that the surrogate will follow the contract?
Ooh, can I take this one? You don't. And the smartest thing that you can do is build a great relationship with your surrogate mom. You want to have trust and care between the two of you. And one thing I always recommend to my clients is, for no reason whatsoever, send your surrogate flowers. Because she needs to know that you care about her, and that you're thinking about her, and that you appreciate her. Send her a gift card for her and her family to go to a restaurant you know she likes. FaceTime her once a week. Look her in the eyes and let her look you in the eyes. Building this kind of relationship is going to take you so far in this journey, and it will alleviate a lot of the individual concerns you might have and the way that you feel, because surrogates are good and honest women, and they want to be a shining star for their intended parents. And when you do that for them, the relationship you build will give you all the good feelings in the world you need, because you really can't sit with her 24 hours a day to ensure she's complying with the contract. So build a good relationship.
And just to add, I think there are three really important points to making sure that your surrogate does comply, or you try your best. One is screening. Psychological screening is key. Two is professional support, an agency or other professionals around the surrogate before she embarks on the journey, so she's fully informed and educated. Travel restrictions, medical instructions, dietary restrictions, all of that she really needs to be informed about. And the last piece that's really very, very important as well is the consultation. So I think all three of us at this panel, as well as a lot of the other art attorneys out there, we really do walk the surrogate through every aspect of the agreement, so she understands that, for example, travel restrictions. In her third trimester, she has to stay within a 50-mile or 100-mile radius of the hospital where she's planning to deliver. Things like that she really needs to understand.
Absolutely, and that's a great point. And I've handled more surrogate contracts, and it really is the process of taking them through page by page, paragraph by paragraph, not necessarily reading every word, but what is in each paragraph and what are their requirements. So great point.
I just want to add one thing. The legal consultation, like Will mentioned, really does become a way that it's a final checklist. It's a final screening tool. So I watch what comes up in the consultations. Sure, it's great if a surrogate's just going to agree to the terms of the contract. Some of what's in there is pretty plain vanilla. But what's great about these cases is that everyone is different. So that plain vanilla contract is gonna twist and appeal to a certain person or a family a different way. So I like to see changes in a contract. If someone reads a travel restriction and is concerned about driving to their mom's house for Christmas, I know she's read the travel restriction. I'd like to talk about Christmas. So I can gauge something by what the changes are. So we're not afraid of changes. And by working with professional ART lawyers, I know that they're going to bring it up. So when I see those changes in redline, I'm assured that they've reviewed those things. So I just don't be afraid of changes, I guess is what I'm saying.
Yeah. So on that note, with changes in the contract, has anybody seen a match break in the legal phase, and why?
I hate to be the one to wear the black hat and break up a match if it gets all the way to legal, but it's absolutely happened, and I'm always grateful. I always tell people that they have cut their losses, and better that than a blow up or a mistake once she's pregnant, or you've spent all that money to line her up for the IVF transfer and she doesn't make it or doesn't show or can't get there for some reason. So if it's gonna happen again, if there's this checklist and something comes up, let that red flag fly, and it happens.
I just had one actually 2 weeks ago where the surrogate's partner refused to have it. It wouldn't be on the contract. They lived together. They were sexually active. He would not be a part of the contract. He wouldn't even talk to me about it. And I said, would you please tell your partner, to the surrogate, would you please let him know that he does have presumptive parental rights, that he needs to understand that we need to talk about this. And he absolutely refused. So I went to the agency and I said, my spidey sense is going off here. Something's weird. This guy doesn't want to be screened medically, and he won't even talk to the lawyer. Something's wrong. You guys should talk to her. They broke the match immediately. They didn't even hesitate. That's also the sign of a good agency, who's not worried about making money and is more worried about the match.
Got it. Great. Well, we hope we've had an opportunity to provide you with some insight into the legal process. Thanks to all of our panelists for being here. We have the contract, we have the parental orders, and we're expressing intent of the parties to make sure everybody's on the same page so that there are no issues later. The issues get resolved in the beginning. We'll be here the rest of the day. Please feel free to contact any of us. Thank you.
Thanks, Greg and panelists. That's terrific. I'm just going to introduce our lunch sponsor, Wendy Wilson-Miller from Gifted Journeys, who's going to come say a few words to you all. Thank you, people. Before I should actually thank the committee who put the conference together. Emily Field, Janae Carell from All Things Surrogacy, and Shelley Marsh have done a terrific job over the last few months. Lots of phone calls, Skype calls, and emails back and forth. So thank you so much for you guys as well. That's great. Wendy. Lunch will be served just out through those doors there, beverages in here, so to get your lunch pack, then come back in here.
I'm not going to keep anybody from lunch very long. I just wanted to thank Sam as well, because he had the foresight to put something together that educates so many people across the globe. And this is just such, for all of us, all of the industry professionals I see in here, it's such a passionate industry for us. We love what we do. We love educating other people, and we really care about the people that we're working with. So if you have any questions for any of us, please use this time to do that. And thanks again, Sam, for everything. Thank you.